If we lose faith in our valued institutions, it is time for the people themselves to remedy the situation. When one of those institutions, the Supreme Court, considered the most revered by many, loses its way, the situation is more urgent. I'm Barry Kibrick, and my guest is James Zirin. With his book, Supremely Partisan, we explore how raw politics can tip the scales of justice. Jim, it is an important book for an important time, and I am so grateful that you've come all the way from the East Coast to be on our show today. This is something that needs to be discussed. Thank you, sir.
Well, I'm delighted to be with you, Barry.
Well, it's my pleasure. This is obviously dealing with the situation that everyone knows about, this partisanship of our country, but when it comes to the partisanship of one of our most revered institutions, the Supreme Court, as I said in the intro, we're now talking business. Something must be done. And this is almost a declaration that says something must be done.
Yes, well, I don't know quite what could be done, but because we have a constitution that controls all of this. But face it, we have a country that is deeply divided along partisan lines. It's a polarized country. We have New York, we have California, and we have a lot of states in between that largely disagree with the views that are held by most people in those two states. And there may be other states that fall in line with the red view and other states that fall in line with the blue view, but basically we're a polarized country. Our think tanks are polarized, our Congress is polarized. So it should not come as a great surprise that the judiciary is polarized. And that's why we've seen in recent years a raft of 5-4, 6-3 decisions. Now, polls show, Gallup polls, that before the Supreme Court was perceived as supremely partisan, the public confidence in the court was great. It was, and the approval ratings were in the mid-60s. After cases like Bush v. Gore and moving on to Citizens United and Hobby Lobby, public approval, according to Gallup, for the Supreme Court was in the 40s. Now, the power of the Supreme Court is really based on public confidence in its rulings. The Supreme Court doesn't have an army like the president, doesn't have money like the Congress. The Supreme Court simply has the moral power of its decisions and whether the public accepts the disposition, because that's how we have a rule of law. And in most cases, even cases that come before the Supreme Court, there is public respect and everyone accepts the disposition. One person sues another person, someone loses, the disappointed litigant says, oh, maybe the judge didn't understand things, maybe the judge wasn't any good, but they accept the disposition because that's our system. But when it comes to a certain type of decision, a core type of decision, which is freighted with social values, I like to say, guns, gays, God, and abortion, then there is a partisan divide. And you take abortion, which is probably the defining political issue of the time, and the country is deeply divided over it. And the Supreme Court is deeply divided over it. And the kinds of decisions that are coming out of the court really can't find as their basis anything that's in the Constitution, but it comes from sources outside the Constitution, namely the preferred policy preferences of the justices. Now, what is interesting is that the partisan divide usually falls along liberal and conservative lines. Now, what is a liberal judge? What is a conservative judge? The liberal judges were all appointed by Democrats, Democratic presidents. And the conservative judges were all appointed by Republican presidents. And the conservative judges favor, in this type of case, certain kinds of outcomes, and the liberal judges favor the opposite outcomes. Now, why is that? It's because of a political division, and that conclusion is unmistakable.
But, I think we need to redefine liberalism and conservatism, because you use Brandeis, for instance, as an example. And I don't know how, because I don't believe he was a partisan judge, so I don't know if you'd have to call him liberal or conservative. I believe Brandeis was a true man of the justice, period. That's my take on him for it. But liberalism, when we looked at classical liberalism from the Enlightenment period onto our founding forefathers, these were all, quote, libertarians, liberty-believing people. Liberalism at that time meant less interference by the government, and now it seems to be shifting a little bit, where the government seems to be a protective barrier for a lot of liberal ideology. And the same goes with the conservative, which is, again, to conserve, to go back, so to speak, sometimes is also almost matched equally side by side for government interference on another level. So in a sense, it seems like we lost what Brandeis said was, to quote you, the right to be let alone, the most comprehensive of rights and the most valued by civilized men. Quote, don't tread on me. That's what Brandeis wanted. And it seems that that's the farthest thing we are now from the Supreme Court, from our legislature, from all of our institutions.
So over the past 40 to 50 years, since the time of the Warren Court, we have seen a development of constitutional values that protect the individual from the government and establish the right to be let alone that was foreshadowed by Brandeis in the early years of the first half of the 20th century. As Justice Kennedy explained it, the Constitution takes away from political vicissitudes certain types of decisions. So it's not the majority rules. It's not the tyranny of a majority that can be imposed on a minority. The Constitution prevents that in certain areas.
But you say in the book that's one of the key problems right now is even the Supreme Court, I'll use your words, the decisions are often not sourced in the Constitution or the law, but in the personal views of the justices.
That's correct. And that is, in my view, an alarming state of affairs because it has prevented the further development of individual freedoms, and rather it indicates a modification and a rolling back of those freedoms.
So I go back then, what I think is, these are your words, or actually I think these might even be Brandeis's words again. Are judges supposed to make the law or discover the law? The most important thing we do is not doing. So I think justices tread on that very fine line quite often of either are they making the law, interpreting the law, discovering the law. That's where we feel, I think, as a society, and by the way, I think, like you said, it transcends the Supreme Court to other institutions. We have lost a sense of faith in these institutions because we're not clear anymore of what their role is or how they should be playing it out.
Is the law a brooding omnipresence, as Justice Holmes sarcastically referred to it as, up in the sky that the judge has to discover? Or is the law something else that evolves and develops over a period of time based on changing circumstances in society, both political, economic, and sociological? Holmes believed that the law develops. He was a common lawyer, and Brandeis concurred. So as we progress as a society, the interpretation of the law must necessarily change with the requirements of the present time. Now, you asked me, does the judge make the law or does the judge interpret the law? Well, those are just words, but the fact is, of course, judges make the law. They just make the law in a different way from the way Congress makes the law. And the way they make the law is they look at the text of the law. They look at, I believe they should look at the intent and understanding of the law, what the legislature meant, or indeed what the framers of the Constitution meant. Then they should look at how other judges tried to grapple with the same problems over a period of years. So they look at precedent, because that's what lawyers do and that's what judges do. They look at precedent and see how close the precedent is to the problem at hand.
But it seems that, and you bring this out in the book, one of the difficult things for all of us to deal with is we're applying a document written in the 18th century to, as you said before, social norms and mores of the 21st century. Yet, when I read the way the Founding Fathers set things up, you can get a sort of implication that the law is, and even the Constitution, is a living document, but how is it to be living and changing? Is it by the way the justices interpret it, or is it by the legislature making amendments, possibly a combination of the two? I think that's when, if people get frustrated, I think it's when the fear of Founding Fathers was that the judiciary would become too powerful. And I think at the same time, we know how difficult it is to change the Constitution. So in a weird way, we've got this, and you intimated that even before the show, we're in this sort of rock and a hard place a little bit. And how do we take this document, take even the previous document? I believe the Declaration of Independence plays a role as one of our founding documents as well, and apply it to our times.
Well, in life, we're always between a rock and a hard place, in a sense, and that will never be avoided. The Founding Fathers, Madison and Hamilton, were not afraid of an overly powerful judiciary. In fact, they kind of left the powers of the Supreme Court for another day. They were much more concerned with a populist majority taking control of the government and through the democratic process, and putting a tyrant, a man on horseback, in the White House. So there were a lot of filters that they put between the people and the government. And it was not until the early 20th century that we had direct election of senators. The state legislatures owned the Senate. We have the Electoral College, which plagues us to this day, where the majority of the people do not elect the president. It's rather the majority of the electors in the Electoral College. And there may be other examples. Now, the Founding Fathers, Madison and Hamilton, spoke in majestic ambiguity: due process of law, equal protection of the law. These are concepts that escape a hard and fast definition. And you have to apply the facts of the case at hand. And what happened, if I just may continue, that the Constitution nowhere provides that there should be judicial review. Nowhere provides that the courts will have the power to declare acts of Congress unconstitutional or the acts of the president illegal and unconstitutional. Rather, what happened was, as we all know, Alexander Hamilton was killed in a duel in 1804. The year before, 1803, he had a pal named John Marshall, first Chief Justice, not first Chief Justice, the fourth Chief Justice of the United States, actually. But Marshall was a great lawyer, and he wrote an opinion called Marbury versus Madison. And in Marbury versus Madison, he said that it's for the judicial department to declare what the law is. Now, Hamilton viewed the judiciary as the weakest branch of government. No army, no money. Had to depend on the political branches of government to exist. But yet, because of its stature, and the respect in which it was held, the judicial branch could tell us what the law is, hence the rule of law.
But in your own words, what gives them that credibility is their moral judgment. That's what you write about. That's what our concern is. When we are talking about supremely partisan, we're concerned that no longer are the justices using true moral judgment. And by that, I don't mean that morality can't have its shifts, but the judge's values, they must be like the judge who you mentioned before, may vote against his own principles because he believes in the moral judgment of the Constitution, the moral laws. That's where I am. If I have my deepest concerns, it's in the moral values on both sides of the aisle, on both sides of the partisanship court.
Well, those concerns are well-founded. So the question, which is the question you've posed, is if changing judges changes the law, what is law anyway? And that is a source of great concern. So one of the threats, I believe, to our constitutional democracy is that presidents, as we have seen, will continue to appoint partisan justices who they think will espouse the views and objectives of the agenda of their political party.
And the warning that you also give us is this sense of balance. And I even think of the liberty, justice. What does she have in her hands? She has the scales supposedly imbalanced, and she is blindfolded, so that true justice is in balance, and it's not looking at you by your wealth, by your ethnicity, by your... That's almost also fallen by the wayside.
Well, I think it...
I want to be careful. Even before you answer, I want to be careful. I say, I don't want to put such a downer on this thing, because I believe as Americans we rise to the top and we will make these adjustments. But I go back to saying it still is a bit of a downer.
Well, Fred Astaire had a song, Let's Face the Music and Dance, and remember there's that line, there may be trouble ahead. I don't think we've reached that point yet, but there may be trouble ahead. And I think I've indicated where I think the trouble lies. I think the amazing thing that seems to occur, and it's is that Republican-appointed justices, at least since Earl Warren, have often taken what you might call a liberal position. And Warren is an example. Brennan is an example, appointed by Eisenhower. In more recent years, you have Souter, and you have John Paul Stevens, and they were Republican-appointed justices who became quite liberal. You also have Republican-appointed justices like Lewis Powell and Potter Stewart, who became quite moderate. You also have Anthony Kennedy, who has voted in the majority 98% of the times that he's voted. He's the swinger on the court, the swing vote. And he is a justice who sometimes votes for the liberals and sometimes votes for the conservatives. So it would be an erroneous picture that you have hardline conservatives on the court who always vote as a bloc and hardline liberals on the court who vote as a bloc. And remember, the Supreme Court is now considering some 64 cases a year. And in most of those cases, which involve ERISA and involve securities fraud and involve even the rights of criminal defendants, in most of those cases, there's no constitutional issue of the kind I've indicated. So and there the justices might line up in all sorts of ways that you might not expect. But you get an abortion case, a gay rights case, a capital punishment case, and if you were to tell me what the issue is, I could predict with great accuracy which justices will vote for which position before the briefs are filed and before there's even oral argument.
And that's the big dilemma that you want us to be alerted to, because if you can tell, which we all can now based on it, it only emphasizes how partisan it is. And you say one of the clearest things that judgment is all about is drawing lines. but you never meant it to be drawn by partisanship. It was to be drawn by this moral value, the judgments that they reached, the understanding of the Constitution, the understanding of what it should mean now, what it meant then. So it's a double entendre in a sense of drawing lines.
But whose moral values and where are the moral values to be derived? When Scalia was around, you had 6 Catholics and 3 Jews on the Supreme Court, 1 African American, 3 women. You couldn't say, they all, except for Elena Kagan, came from the lower federal courts. You couldn't say that as a group, 100% minority, as a group, they were representative of the American people. I mean, no evangelicals, no Buddhists, no Muslims, no gays that we know of. And how can you say that this is a representative body? And even if it were, where do they get their moral values from?
But you know what's even more frightening is that even as we're discussing the diversity of the court, we're only discussing diversity by race, ethnic creed, we're not really expressing diversity of thought. Now, they may have diverse thoughts, as you brought up, but the fact is they're not being elected because of their diverse thoughts. They're being selected because of their ethnic background, their political view, this is where the problem is really manifesting itself.
Well, you raised the issue, which I raise in the book, of identity politics. And we have identity politics in America. I mean, when I was a kid in New York City, we had a ticket of Lefkowitz, Gilhooly, and Flynn against a ticket of O'Connor, Wagner, and Procaccino. There had to be one from Group A and one from Group B. And in a multicultural society, that's how everyone was satisfied.
So then let's go back to one more situation that I think is important. Since we know that the main pride we will have in our courts is, as I go back, if we have justices that have moral judgments, even though how we define morality, as you said, it may be if you're Catholic, you may have a different moral view than if you're Protestant or if you're Jewish. It may be different if you're black or if you're white. But there still is a human, non-moral, relativistic view that we do know certain things are right and wrong. Not all of those come so easily to the Supreme Court, but we do. And yet, if we lose faith in our justices, we then begin to lose faith in our other institutions.
Well, that is certainly true, because the judiciary is a co-equal branch of government, and take the situation which was visualized by Hamilton, which he was so afraid that a despot would become the president and would engage in lawless action. As I say in the book, at the end of the book, and this was before Trump was elected, who but the judges are to push back against him?
Jim, I told you before you got here, we could spend hours. We're already so far over our time. I just couldn't stop us. I'll have to trim around later, but it was a pleasure having you. I want to end with these words. Just what are we to take away from this glimpse of supremely partisan court? I hope we have made the case that there is more to judging than a detached analysis of facts, text, precedent, and historical setting. Mr. Zirin, you did it. Thank you, Jim, so much.
Thank you so much
for the book. It's my pleasure.
A pleasure. Delighted to be with you.
Oh, it's my pleasure.
You so much.
And thank you guys for joining us. Now, before we leave, I'd like to leave you with these words from Supremely Partisan. When the 9 justices of the Supreme Court of the United States meet, each shakes hands with the other, each of the other 8, a total of 36 handshakes. This tradition, which has existed since the late 19th century, is said to signify shared purpose. yet the symbol of unity is belied by the fact the court is deeply divided along partisan lines, and its decisions frequently reflect the polarization of American society. I'm Barry Kibrick. Between this great divide, we must make those 36 handshakes meaningful again. Thank you, Jim.
Amen. That's wonderful.
My pleasure. Thank you. Thank you very much.
To connect with Barry, like him on Facebook and follow him on Twitter @Barry Kibrick. And to contact Barry directly, view past episodes of Between the Lines, and read his weekly blog, visit us at barrykibrick.com. Between the Lines with Barry Kibrick is made possible in part by Sam Ash Music, a proud sponsor of Between the Lines with Barry Kibrick. Sam Ash has been serving musicians since 1924. To unlock your inner musician, information is available at samash.com.